All right, good morning, everybody. We're back on the record in state. This is Ashley Benefield, 2020 CF 3014. Thank you for your patience as we've gotten started this morning. First thing, we had early this morning, a juror call in that there was some car trouble. Juror was running late. My understanding is all the jurors are here and they've been brought up. And then obviously I've had computer problems this morning, so we'll just get going. Anything you need to bring up before we resume with the defendant's case in chief?
Judge, the clerk notified me on Friday that we had not actually entered states 103 and 104, so I would like to go ahead and enter those. I don't know if the defense has an objection. We can do it in our case in rebuttal if we need to, but we did talk about them during testimony. I just didn't say the magic words.
I just don't know what 103 and 104 is.
I don't either.
Modeling picture and the mugshot.
Oh, actually, yes, we do have something to say about that.
All right, so you're just going to save that until your rebuttal? Okay.
Yes, and then just to put on the court's...
There's a discovery issue with respect to those two photographs. We were never provided them.
Well, the mugshot.
All right.
Certainly.
So I'm making a note that we have to have a Richardson hearing on that issue then.
And also just to, for scheduling purposes, at some point, hopefully before right at lunch, I would like to have a discussion about whether the court would allow the state to introduce evidence from Dr. Broder that we had previously talked about before. I just wanted to get a ruling from the court so I know whether to get him here or not.
Okay. I don't know what evidence it is, so I'll just wait for you to bring it up.
Okay.
Defense, any issues before we resume?
No, sir.
All right.
Ready.
State, you ready?
Yes.
All right. You said ready.
Yes, sir.
All right, just want to make sure. Are you feeling all right?
Yeah, picked up a little cold, but I'm good.
Same here. So, I understand. Okay. All right, you all can have a seat. Welcome back, everybody. Good morning. I don't know who had car trouble, but I hope everything worked out and you've had time to kind of calm down from that. So we're going to get started. As when we left on Friday, the state was presenting the defense was presenting its case. I do need to ask you, though, before we get started, because we just had a couple of days off, did anybody discuss the case amongst yourselves in any way? Did anybody discuss the case with anyone outside of this jury? Did anyone do any research or watch any coverage at all about the people, places, things, or legal topics we've heard anything about?
No, sir.
All right, everybody says no. Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Bruce Ferris.
Please stand with me, sir.
Certainly.
Face the podium, raise your right hand and be sworn in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. Morning, Judge.
Morning, sir. My name is Judge White. I'm going to be presiding over this case. Just have a seat, make yourself comfortable in that chair. Get yourself about 12 to 15 inches from that microphone. It's pointed straight up, but it does adjust down, left, right, up, down, whatever you need. And you just speak directly, the loud, clear voice into the microphone. It should pick up everything.
Okay, I will.
Good morning.
Good morning.
Will you tell us your full name, spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
How long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes. Been to a lot of training seminars and certifications and various conferences. In my curriculum vitae, I'll call it a CV, my resume, there's about 100 items listed of trainings that I've been to over the years.
For what specific field?
In domestic violence and mental health and trauma to children and trauma in general, and I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about it, please.
So as a counselor now, my day is spent seeing individual clients. I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems. I also counsel adolescent boys, most of which are going through the foster care system or adoption or divorce of their parents, etc.
All right, and what position did you hold prior to that?
I was a police officer in Gainesville, Florida for 20 years. I graduated the police academy in 1993, got sworn in 94, and I retired in 2013. The last 10 years of that career, I was a detective, uniquely running. I was the lead detective of what's called the Domestic Violence Unit of the Investigations Bureau at the Gainesville Police Department. Over the course of that time when I retired, I looked back and did a little search, and I had arrested or filed charges or got warrants on 500 different abusers over those years.
Mr. Ferris, give us an idea of your professional credentials. Lightly.
Sure. I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a Batters Intervention Program facilitator. In case anyone doesn't know it, Batters Intervention, which I'll refer to as BIP, is a 6-month class given to abusers who are found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel, and it's a psychosexual type, not sexual. It's a type of therapy that involves some counseling and some ownership and learning. And also, was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of Johns Hopkins University. And I also have a certification as adoption competency training, mental health for mental health professionals out of Rutgers University. I'll stop there.
And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Give us a brief idea.
Okay. The Alachua County Board of Commissioners had nominated me to Governor DeSantis to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Varnes Award for Outstanding Achievement in Prevention of Domestic Violence Against Women. I had recognition for valuable contributions in what's called crisis intervention team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation. I'll stop there. There's a few more.
Have you been recognized as an expert on domestic violence in various courts of the state of Florida before?
I have.
Approximately how many?
So I've been involved in 60-some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batter's intervention, effects of DV on children.
All right, and when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
But both. I worked for the state attorney's office and worked for defense, and a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know it's battery, assault, ag assault, false imprisonment, sexual abuse, etc., person crimes involving a family or household member against each other. And that has another definition. That's spouses or family members living together, or it could be a couple that had a child together that have never lived together. It doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. The abuser needs to control their victim. Now, they'll use the criminal things, hitting, et cetera, all those things, but in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCF's accepted for the BIP class. I'd like to explain the Power and Control Wheel, if that's okay.
In fact, with the court's permission, we could perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser pointer in front of you. The little star in red will provide you with
Okay.
the dot.
Judge, may I stand here and pay attention to the mic as I talk?
Any objection?
Okay. So as I mentioned, there's the criminal definition.
Was there a question? Objection. Was there a question?
Go ahead with the question.
Yes. What is it that's on the
Right.
screen?
So what
Mr. Ferris?
Okay, so-
Mr. Ferris,
yes, sir,
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power and Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, making shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
Now, I have a couple of questions I'd like to ask you about that wheel that you demonstrated for us. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who've come through the shelter, and through a period of time they developed these 8 items and created the power and control wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Batteries and Prevention Program class I talked about, and it's taught quite readily all across America and by use by domestic violence shelters, etc.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so, could be a little more.
Are there any agencies within the state of Florida that predicate their decisions upon the Duluth Power Wheel?
Yeah, the DCF accepted the power and control wheel for the curriculum for the BIP class.
That's the Florida Department of Children's and Families.
They were the ones who were controlling the BIP class when it started up. Also, a lot of federal money, domestic, against women act, things like that have always promoted the power and control bill, and also, giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at the least. And in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, there's some different statistics. Somewhere between 2/3 and 3/4 are men, and
are men as victims of domestic violence?
2/3 to 3/4 abusers. So that on the other side of that, they're 1/3 to 1 to 25% male victims. And I just got a male victim this past week.
Okay, so look,
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You've told us that the percentage of abusers that are male is approximately 2/3, is that
At least
correct?
2/3. There's some statistics to make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3 to 3/4.
All right. Now, I want to ask you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
And I certainly can do that, Mr. Teller. Can I make one closing statement about the Duluth wheel? And
Sure.
Power and control. So I think it needs to be said, maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those criminal, the battery, or they use emotional abuse or intimidation, or use different techniques to try to control them. So the victim of domestic violence is placed with wanting to have the least harm to them. So they get into a compliance, I call it an equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want. They believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply. And they get in this compliance mode, and they can certainly appear to society as nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen. So
All right,
I'll
so-
go on from there.
This wheel then is the product, if you will, of the science of domestic violence over the past 30 years.
And throughout my entire practice, the thousands of people that I've counseled and even the 500s I've arrested, I see this repetitively to be true.
All right. Now, would you please tell us,
Oh, I do. Thank you.
I need you to make sure you keep your voice up so that
Yes,
others
sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior, abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so,
Object to
Sustained.
non-responsive.
okay. Can I explain why they abuse pets?
Yes.
So if a pet is belonged to the female or their partner, the victim,
Judge, I'm going to object.
Can you approach, please?
Mr. Ferris, would you describe for us what the term coercive control means in a domestic violence
Sure.
relationship?
So coercive control, acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And,
All right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often, when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And
What
if I'm
is the victim trying to accomplish by engaging in the appeasement behavior?
not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression. So they don't want to again poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante, we'll speak.
Objection. I have the same objection as at the bench.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern, excuse me, Is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
And I can say a very high percentage, well, I don't know, over 90% I'd estimate of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone, it's one of the 8 categories is minimizing, denying, and blaming, and it's all a technique. Like she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes. Very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser is there. There's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
Sustain.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions
Certainly.
involving the hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps. Placing a tracker on the victim's car, an illegal tracker. Throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no-contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control wheel and right off my experience. They're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt. These are, again, techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So, yes.
Lastly, one other factor I neglected to mention, would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely, and it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident...
Judge, I'm going to object to non-responsive.
Overruled.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question as it relates in general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember And is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about.
Sustained.
Yeah, just
So
academic.
yes, definitely, they don't forget the abuse that's occurred to them, trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Ferry.
State, Cross.
Thank you, Judge. Good morning, Mr. Ferris.
Good morning.
Mr.
Mr.
Okay.
Oh,
I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
sure.
Minimizing the abuse.
Now you're asking me if the victim would minimize?
Yes. Like, what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame.
Yes,
Okay. Making excuses for him
definitely.
or her, I guess, but not reporting the abuse.
Right.
Dropping charges if they were filed.
Yep.
Not standing up for themselves
Yes.
and not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each.
Sure.
Okay. Sorry, Judge. While she's fixing it, and I know you're familiar, and do you have a copy in
I
front of
do.
you? I do too.
I want
do
right
too.
in front of me.
Okay. And so I want to talk first about the use of intimidation. Would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic?
Yes.
If it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse.
Mm-hmm.
Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse,
Right.
would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically?
Mm-hmm.
No financial dependence on the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario given me, it doesn't sound like it would apply.
Okay. And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think. Living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor. for my scenario.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children. If the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me, if I could just reframe, that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty, I'm just asking if that would apply. We've talked about how these
Right.
things apply.
It may not apply, it would not apply, but I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it, I'm just asking hypothetical
Okay.
questions. How about the using a male privilege? If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me, if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles, and when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man, I purchase things, I control things for you, I decide what to get, etc. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mine. I think it kind of goes with the economic abuse, and what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else, and he is, yes, of course, and he does it. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
Okay. How about minimizing, denying, and blaming? What, you said that was present in 90% of the cases.
Quite a bit, yes.
Right. I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong, I lost control, I shouldn't have done those things, and never says it was your fault you did those things? Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that.
Okay.
Because it could be that part of the strategy of minimizing could be that, I'm sorry, I didn't do it. That could just be minimizing.
I'm sorry no, not I didn't do it. I'm sorry I did it.
Right.
That's part of
That's still-
minimizing?
Yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I
facts.
guess I need an explanation on if somebody takes responsibility for accusations against them,
Right.
how that is minimizing. Just to say, yes, you are correct, and I am sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite.
Yes,
That person
it could
is
be.
taking credit, is taking responsibility for their actions.
Right, certainly it doesn't deny that it happened, that's for sure.
Right.
Okay.
And no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel
Right.
and whether or not if somebody, under my hypothetical, admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would need more information on the relationship in this scenario to decide that.
Is there a scenario? Okay. How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry, I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no, it may not.
Yeah, I can't help you with that. I'm not asking the questions.
Oh, I was asking you one. If there was
I
a
know,
scenario.
I'm not. You are.
Would you take into account, based on, with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario, she does not live with him, she's actually in another relationship, potentially engaged to a new man.
Okay.
She tells him that she does not want to be with him,
Okay.
and she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So, if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence, but that's it. She's not appeasing, she's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently, I keep saying independently wealthy, that's not what I mean. Independent, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts?
Yes.
With no allegations of,
Yes.
no allegations of emotional abuse in years?
Yeah.
It's your opinion that not good enough, they're still on this power
Well,
control?
all I can speak from my critical learning and studying this, and also my practice, and I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
Yes.
Sir, you are released from your subpoena. You're free to go.
Thank you for all your help.
All right, Mr. Taylor, call your next witness.
Gina Torsa, Your Honor.
Judge, I think we're going to have to approach whoever comes in first.
Thank you.
Okay.
Defense calls Gina Torsa.
Now, before you face the clerk, raise your right hand if you want to.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
I do.
This way, please.
Actually, as she's sitting down, attorneys come back one more time. Hello, ma'am.
Good morning, Your Honor. How are you?
Go ahead and have a seat. My name is Judge White. I'm presiding over this case. Just make yourself comfortable in that chair. You want to be about 12 to 15 inches from that microphone. You can adjust it up, down, left, right, however you need. And if you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torsa, Torchia.
Ms. Torsa, did you at one time work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torsa, what I've marked as Defendant's Exhibit number 25. And ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Overruled.
All right, now,
Defendant Exhibit 25 will be received.
Ms. Torcha, did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torcha, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.?
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Can you slow down just a little bit?
Oh, I'm so sorry. I'm a fast reader.
Okay. Well,
Sorry about
slow
that.
down a little bit for us.
Evelyn Wood School, huh?
Where do you want me?
You're good.
Okay.
6 months of the day of the hearing.
Which was May, November, which was May, November 3rd.
Ms. Torcha,
Yes.
I'm sorry. Would you start over, please?
Yes, sir. Gina, I noticed something that you both need to be aware of. Unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay, we can agree that SAO would be state attorney.
Yes, sir.
So, lastly, Ms. Torsa, this is Detective Gillum telling you that the order was in effect, the stay-away order,
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
This is Detective Gillum explaining to you.
Objection asked and answered. She read the email.
Sustained.
Just a moment, Your Honor. This is for sending Ms. Torsa, let me pass you what I've marked as Defendant's Exhibit 26.
Can I see it, please? Can I see it? Can we approach this?
So, Ms. Torsa, let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gillum.
Yes, sir. Yes, this is the order.
Yeah, without referring to it, my question is only, did you, in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gillum?
Yes, sir.
And then he responds to you a couple hours later with the email that was introduced.
Yes, and there's also
No further questions, Your Honor. Thank you, Ms. Torsa.
Any cross?
Can you finish your answer, please?
Yes. There's also a predicament where Detective Gillum, there was no order entered in to the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask to
further questions.
disregard,
Thank
Your
you.
Honor.
Members of the jury, testimony regarding an opinion's witness about violation of criminal law is inappropriate, then you should disregard those last comments.
No
Anything
further
else?
questions. Thank you.
That's sufficient, thank you, Judge.
Redirect?
No,
Can the witness be released?
yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
Francis Scott, you have this report.
Mr. Taylor.
Right, I wonder if we could publish the exhibit that.
No.
That's okay, I'm not gonna be able to go very far with that.
Judge, I think we're gonna have to approve.
Okay, well, let's go. All right, members of the jury, I think it's a great time for our mid-morning break. So I'm going to sit you out, give about 10 minutes or so. Feel free to use the facilities. You can use your phones if you need to send or receive text messages, emails, phone calls, anything like that. Please don't begin any sort of deliberations or discussions amongst yourselves about the case. Don't discuss the case with anybody outside the jury. And don't do any research on the people, places, things, or legal topics we've heard anything about. And 10 minutes, 15 minutes, because I also want to give everybody else a break as well. So, see you back in a few minutes. Y'all can have a seat. All right, so the issue is a police report that I haven't seen, but it's my understanding what it says is that Ms. Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me. With
You had it right so far, Judge.
All right, so this isn't marked. Is it, did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the sheriff's office that Ms. Benefield went to the telephone reporting unit on December 6, 2019.
Phone call.
That Ms. Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past. That she has observed him driving behind her on multiple occasions, which concerns her. And she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed. All right, any objection?
The objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information, but anything contained in this report is hearsay other than that Ms. Benefield physically appeared at TRU on December 6, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if you remember.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense. I do not plan to ask the deputy to read it. I'm going to ask him if he took a report from Ms. Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And that's hearsay, in the state's opinion, Judge, because it's self-serving hearsay at this point. It's actually hearsay within hearsay, I think. That if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least one level.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle, and my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in, and I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about them. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. What was who's the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay. Scott
Lindsay.
It's on the top of the report. Judge.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling him for, so. Yeah.
All right, I do want to give you all a break, though. I know we started at 9. It's about 10:30. I think it's reasonable to go ahead and take a break. So, why don't you guys take 10 minutes?
Thank you, Judge.
Court will be at recess in 10 minutes.
All right, welcome back, everybody. We are back on the record.
Please have your seat, please. Ma'am, please have your seat.
All right, Mr. Taylor, do you have your next witness?
Defense calls Vincent Vizzacaro.
You ready?
Yes.
Okay. Yeah, let's go ahead and bring him in. Please make sure you have him spell that for the court reporter.
Virtual, it's just like it sounds.
Do you need the...
Please.
But we'll wait to turn the lights down until you give us the high sign and the clerk will turn them down.
All right, thank you.
All right, you all can have a seat. Welcome back, everybody. Hope you got to stretch a little bit. Maybe run and jog in place, warm up a little. So we've got the defense going to call their next witness, but before we do that, I did want to ask that anybody begin deliberations amongst yourself, speak with anybody outside of the jury about the case, or do any research on those topics we've talked about. Everybody says no. Mr. Taylor, call your next witness, please.
Thank you. Vincent Vizzacaro.
Case the clerk, please go ahead and
Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Hello, sir. As the deputy said, just make yourself comfortable in that chair. My name is Judge White. I'm going to be presiding over the case. You can adjust that microphone up, down, left, right as you need. Stay about 12 to 15 inches away. Speak in a loud, clear voice. It'll pick up everything.
Sounds good.
Good morning.
Morning.
Would you tell us your full name and spell your last name for us, please?
Vincent Vizzacaro, Vizzacaro.
All right, Mr. Vizzacaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long have you been doing that?
About 8 years now.
I want to ask you whether or not back in 2018 you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a home.
Hearsay.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzacaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizicaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach, Jen?
Yes. All right, members of the jury, I do need a few minutes to resolve a legal issue. That's my responsibility. So if you could, close up your notes and leave them there on your chair. And I'm going to excuse you back into the jury room for a couple of minutes. I will get you back out here as soon as I can. Don't begin deliberations. Don't talk with anybody outside the jury. And no research on any of the issues. Thank you. All right, you all can have a seat. Mr. Vizicaro, what I'm going to do is at this moment, I need to do some research and speak with the attorneys.
Okay.
So I'm going to excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties. Mm-hmm. And that means that you cannot discuss your testimony or the questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked or what testimony they gave while hearing court, or do any research on the case, watch it, or anything else.
Understood.
All right, we'll call you back as soon as we can.
Okay, thank you.
Thank you. I'm just going to ask before I start doing my research, do you have any cases that you want me to know about right now?
No, Your Honor.
All right, so let's, I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803 6.
Understood. All right, so I'm thinking it's going to I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I want to look this up as well because I want to find a case that gives me some direction.
Okay, yes, sir. Thank you.
Of course, that means you can too when we go back on the record.
Yes.
right, you guys ready to go back on the record?
Yes.
Yes.
Printing something.
All right, the objection is hearsay. Any other objections?
Judge, also, I would like to make a relevance argument that the fact that he's going back and forth in this email about a specific property, there's no relevance to it.
All right, proponent, go ahead, sir.
Well, I think it's admissible, one, as a business record, which we've already qualified. Business records traditionally contain hearsay, and under the statute, Your Honor, specifically subsection C, we got this email from the state. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection, according to the business records exception. We also believe that it shows Doug Benefield's state of mind, that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
All right, anything else, sir?
No, sir.
State?
Judge, I found a case I would like to put on the record, Thomas v. State, 993 Southern 2nd, 105 from 2008. It is specifically addressing an email that was put in as a business record. I didn't have long to read this, but it was an email that was sent to an apartment complex manager of some sort, and it appears as though it was not qualifying as a business record, and additionally the hearsay within the email was not admissible. There is a yellow flag, and I'm trying to look at it now.
State. Mr. Taylor?
Yes, sir.
All right, do you want to make any argument on it?
No, sir.
So Thomas v. State is helpful. It's 993 Southern 2nd 105 1st DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, I seem to... I don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzacaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Vincent V State, Vanzant, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is his state of mind. It clearly shows Mr. Benefield. Let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence, and here is Mr. Benefield, Judge White, negotiating with the realtor to buy the house directly behind the home where Ashley Benefield lives, and he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice. That corroborates the defense.
Do you want to be heard on 90.8033, then existing mental, emotional, or physical condition?
Judge, his emotional, mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
All right, as I've said before, are you going to establish the location of the home through Visicaro,
Yes, sir.
where it was,
Yes, sir.
in relation to the house where Miss Benefield lived?
Yes, sir.
And then are you going to then just argue during closing, I would assume?
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just.
witness-wise.
This is an isolated act of DV. Yes.
All right,
Judge, if she didn't actually know about this, and I don't know that it's relevant.
well, and that's what I was thinking, because, hold on, it's not an act of violence, though.
Right.
Or threat. But under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design, when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time, or prove or explain acts of subsequent conduct of the declarant.
Then, Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have, that you asked if he was assisting him in finding a location. Did you find one? Where was that location at that you were talking about putting an offer on?
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On behalf of Ms. Benefield, though, I would like to present the best defense that I can. And I think that the email clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
All right. Thank you both very much. I'll allow the admission of Defendant's Exhibit 27 under 90.803(6) for the Realtor's portion and 9803(3) for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
All right, can you bring the witness back in, Mr. Visicaro? All right, welcome back, sir. Just take your spot back there in that chair. We're going to get the jury back in and begin your testimony.
Sounds good. Thank you.
We'll bring them in. to you. All right, y'all can have a seat. Welcome back, everybody. Get ready to begin deliberations. Talk with anybody outside the jury about the case or do any research. Everybody say no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge White. Mr. Vizzacaro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Vizzacaro, what I've had marked as defendant's exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's exhibit 27 will be received.
Now, Mr. Vizzacaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you. And as luck would have it, you have the pointer. Okay, so this will give you
The beam?
the
Okay.
Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay. Do you know, Mr. Vizzacaro, who was living in the house with the red dot at 11331 White Rock Terrace?
No, I don't.
And do you know whether or not, if I may, you know whether or not you don't know who was living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Sant lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further. Okay. oversight. I'm going to pass to you what I've marked as Defendant's Exhibit number 28. I ask you if you can identify it.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in Exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport News Circle,
On
excuse me.
behalf of Ms. Benefield, Your Honor, move to introduce that as Defendant Exhibit 28.
No objection.
Received.
That's all. Thank you very much, Mr. Fisicalo.
You can wait.
Gotcha.
Cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just
That's right.
grab it real quick. And for the record, this is State's Exhibit 27. And it appears as though you're speaking with Mr. Benefield about potentially this house coming up, or the price being lowered on this house, correct?
That's correct, yes.
All right. So you were contacting Mr. Benefield about that?
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation, yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top, so you might be able to.
That's why.
For the record, Defense Exhibit 27.
I'm sorry, Defense Exhibit 27. Does he say there that he needs to speak with Ashley first?
It appears that way, yes.
Okay.
Yeah.
Thank you. No further questions.
Can you redirect?
Nope.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Mr. Taylor, can you state, defense, can you approach real quick? All right, call your next witness.
Defense would call, Your Honor, Dr. Jason Kintel. Yeah.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
Yes.
Hello, doctor. Welcome back.
Hi there, thank you.
As you may recall, my name is Judge White. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
Good afternoon, Dr. Kintel.
Hi there,
Welcome back.
thank you.
As a result of the counseling sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. opinion testimony.
You go ahead and approach.
Dr. Kintel, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection. Qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both Ashley and Doug.
All right. And in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes. Both when they came in as a couple and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
A brief deviation, Dr. Kintel. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in '98 and started working in the public school system. So since '98, 2006, I started a private practice.
And since you've been in private practice, Dr. Kintel, can you give us an idea of the number of patients that you've seen and counseled?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay, and when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment. Right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. Mm-hmm. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And in that process, do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Mm-hmm. Okay. Now.
So more instead of a suggestion, it's more of kind of a mutual outcome.
All right, and you went through this process with both Doug and Ashley Benefield.
I did, yes.
All right. Your Honor, I would tender Dr. Kintel as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people. I look at people because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or, bipolar, I would say I work with people, not the disorder.
Okay. So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Okay. Thank you for this question.
You may resume your question.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Kintel as an expert.
And I
Have
would
you heard any-
object.
Same objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Kintel, all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Kintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise?
Overruled.
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child, and I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Thank you.
Does that refresh your recollection, Dr. Kintel, as to Doug's perception of letting Ashley get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Kintel, did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
Sustained.
Did you reach any conclusions, Dr. Kintel, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child, and I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed with Emerson and the child outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
Cross.
So you mentioned that it bothered you, or at least you noticed when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child?
Yes, I did.
Okay. And I believe, correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times.
Yes, ma'am.
And you met with Doug Benefield alone twice.
Yes, ma'am.
And you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashley Benefield. Over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield?
No, ma'am.
Okay. Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're releasing your subpoena. Thank you very much. Here you go.
Thank you.
Can we publish the couple of exhibits that we put in through Ms. Zakaro?
That's the wrong one.
And then I think a whole bunch of break for lunch.
27.
I don't think that's.
Oh, that's not.
Yeah.
Oh, you have 27?
27, 28.
One photograph was already in,
One.
and then one we added together with the.
Yes, so members of the jury, we're going to pass these out and publish them. I'm not rushing you, but I'm going to talk while we're doing that. I think at this point, it's a good time for our lunch break. It's about 10 minutes after 12. So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
Exhibits 26 and 27.
Those 27 and 28, and they'll be marked on them. There's a little sticker on each. Which should say 27, 28, and I think the other one is Defense Exhibit 1. All right, so it's 12:15. If I could have you back down in the jury assembly room where you began everything this morning and last week at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury assembly room at 1:30. We'll get you back up here as soon as we can to get started for the afternoon. Remember the admonishments, don't talk amongst yourselves with anyone outside of the jury, or do any research on the people, places, things, or legal topics we've heard anything about. Thank you. All right, y'all can have a seat. I would assume, before I let you all go, that the request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
right? And certainly a list of witnesses that are expected to be called.
Yes.
Right. I didn't get a copy of that. If it's been amended from the witness list that I received, it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap for this afternoon?
So we
I don't need to
have-
know the order, but just who?
We have Jason Alexander, Michael Haig, Haag, Dr.
Hold
Emma
on one second. I'm sorry. I got it. My list is, okay. Michael Haig.
Michael Haig, Dr. Emma Lou,
All right.
and Warren Justin.
Warren.
Justin, the lead homicide detective.
All right. When we, none of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would much rather have the objection made, let's talk about it, and then let's call the jury in so it's a little bit smoother.
With Detective Warren, I may have objections, but I don't know what's going to be asked. So without asking what they're going to ask, I don't think we can have that conversation. And additionally, if Detective Gillum is set to testify, I would have similar objections.
You didn't say that name.
No, they've been keeping him here, so.
Okay. You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonable good chance we rest today.
Okay. Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal, Okay,
So the one request I do have, Your Honor, is for Mike Haig, who's our ballistics expert.
Mike,
We need it.
Mike
Mike Haig.
Haig, yes.
J-A-G.
Okay,
We need the HDMI cable to run to the witness stand so he can plug his laptop in.
to where, here? I don't understand.
Yes.
Project it.
Yeah, so it'll be up on the projector.
So he's gonna use his laptop to
Demonstrate
project here.
his testimony, yes, sir.
I know this is the one we used. I don't know, Deputy, does that stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need
HDMI.
that a witness this afternoon is going to have to run to that?
Yes, sir.
Thank you so much. And then that'll take care of both because my goblins just you know how it goes.
Okay,
All right.
thank you, Judge.
I guess the only other questions they would have is there were other witnesses that were held by the defense. If these are the remainder of their witnesses, are those witnesses being released? Because they're asking the state for the most part.
We don't know what they're presenting in
Yeah.
rebuttal.
Okay. All right, welcome back, everyone. It's after lunch in 2020 CF 3014. Is the jury up? All right, jury's being brought up. Anything we need to talk about before the defense calls their next witness? Oh, I'm so sorry. I was looking right over top.
Governor now.
Oh, it's a good point. We can check and see if this thing's working
It
again.
should be.
All right, looks like my real-time viewer is working again. All right, welcome back, everybody. It's after lunch now. We're all back in 2020 CF 3014. Is there anything we need to talk about before the defense calls its next witness?
No.
All right. As soon as the jury comes up, let me know and we'll bring them on in. Okay.
Yeah.
We have Justin Warren.
All right, y'all can sit down. Welcome back, everybody. As we were breaking, I saw some folks got new pads of paper, and everybody's pen is still doing okay? All right, just let us know if not. I hope you had a good lunch. Did anybody discuss the case amongst yourselves? Talk about the case with anybody outside of this group, or do any research on people, places, things, or legal topics, or get any information about the case?
No, sir.
Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Judge White. Defense calls Justin Warren.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Oh, sir.
Thank you.
Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just up, down, left, right, however you need. Loud, clear voice, and we'll hear everything.
Yes, sir.
Your Honor, with the court's permission, permission to treat as adverse.
You can go ahead and approach. Bless you.
Detective Warren, good afternoon.
Good afternoon, sir.
You were the lead on this case, were you not?
Yes, sir.
Will you tell ladies and gentlemen of the jury, what does that mean, the lead detective?
The way that our unit works, the Manatee Homicide Investigative Unit, the lead essentially during a homicide investigation is elevated to essentially almost the rank, not a sergeant, but basically has some of the same responsibilities as far as handing out assignments and then collecting the information in the end.
And is amongst the ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right, does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
Do you recall being asked the following question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
The answer's still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair,
Yes, sir.
with conclusions supported by evidence?
Absolutely. Yes, sir.
Yeah, not speculation.
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms.
Objection.
Benefield?
Pre-trial rule.
Just asking the question.
Overruled at this point.
Did you submit an arrest affidavit for Ms. Benefield?
Yes, sir.
Did you represent that
Objection. Pre-trial rule.
Sustained.
did you describe
Objection. Pre-trial rule.
Go ahead and ask your question.
let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield that it did not appear he was facing Ashley Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from
Objection.
the front.
Hearsay.
Sustained.
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry.
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front?
That's not the way that it appeared when we did our preliminary investigation with the medical examiner and then later on.
Yeah. And it's your position today as you sit here that...
Objection, Judge. Can we approach this?
All right, members of the jury, we're going to need a couple extra minutes to handle this one. If I could ask you to step out, close up your notes, step back in the jury room. We'll get you back in as soon as we can. Remember, don't begin deliberations, talk with anybody about the case, or do any research on the people, places, things, or legal topics you've heard anything about. Thank you. All right, sir. We're going to need to address some legal matters about your testimony, so I'm going to ask you to step out into the hallway. The rule of sequestration has been invoked, so you're not to discuss the questions asked of you or your testimony with anyone. You're not to talk with other witnesses about their testimony, the questions asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
All right, the witness is out. So as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the long-standing doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve statements made by the detective in his probable cause affidavit or arrest affidavit. All right, so these issues were addressed, and I seem to recall that I allowed these at the Stand Your Ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pretrial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown at the time of the cross, or the direct and the attempted impeachment to show that those criteria are met. So, State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues so we would not have this problem in the middle of trial. Now, almost every sentence that comes out of Mr. Taylor's mouth, I have to object because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object 5 more times. He has clearly only called this witness for impeachment purposes. That is the number one first objection that I have.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, that is my substantive evidence predicate. And based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state? So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair, conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders? If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition. I don't see why that is not fair game, respectfully. The only other question I had of him was he had authored a supplemental report on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashley Benefield, and he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
What report is that?
That is a report that he authored, a supplemental on November 16th of 2020. And referring to Ashley Benefield as it relates to the victim, Douglas Benefield, he wrote or checked the box that says no bias.
What are the other options?
Well, the other options are hate, spite, ill will, and
on that form?
No, the form it's an open form. It's for him to put it in there. Here, I'll show the court the form. It says bias motivation, he types in none, no bias. The next block says bias target, it's blank, and the box after that says bias circumstances. That too is left blank. Would you like me to show you?
Yes.
First, I don't think he filled that out.
Even if he did, I don't know what it's.
Now, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
All right, the line, thank you. The line of questioning that you seem to be starting with was the line of questioning at the stand your ground hearing where a narrative was established and then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness, hit Ms. Benefield with a box, and I want to ask him if he knew who that witness was, and he's going to tell me it was Doug Benefield, and I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that, rather than put a witness.
Judge, I feel like we litigated all of this. And this was supposed to be shown to the court outside of the presence of the jury so you could make a predetermination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He calls him and says these questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment. We have gone over this before, that what is in this arrest affidavit is irrelevant. What the judge signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why is he attacking the credibility of a witness that never testified?
So as I understood the
Final
court's
thoughts.
ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides are murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times
Yeah.
in multiple hearings.
Yeah.
Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least 2 deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens. Who? Dickerman. Who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there's been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors, if you feel her action was justified, then she's not guilty, because not all homicides are crimes. How could that not be relevant?
This witness never testified.
Any further thoughts?
No.
All right. Yeah, these we've already covered this ground. So it answered a question just a moment ago about what was the purpose for calling this witness, and the law is very clear, and I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? Those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, and I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But the answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders, or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge Kintel, may I ask the court?
I tried to give both sides as much time as they wanted to put information on the record. The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly biased in any way, or how that would be relevant to this particular case when it's an opinion whether people are killer murderers. That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about the statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court think if, as the lead homicide detective, Justin Warren would have said, I'm not going to seek a search warrant because I think Ashley Benefield was abused and I think her actions were justified? That would be his opinion. But if that was his opinion, she might not be sitting there right now. That's why I think it's relevant. He initiated the prosecution. And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
State, anything else?
No, Joe.
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
All right, I have two questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show him the DNA report and have him read the section that's applicable. We gave them business records notice.
I have,
Well, hold on.
okay.
The two questions that have been stated at this point, the two questions, just to try and get objections out of the way and get them ruled on so we can get this going, is one, two is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant. I think he's already testified to
I
that.
think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
The DNA.
DNA report.
Yeah, he submitted the exemplars and he got the report back.
All right. I don't know if I've seen that.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah. Plus, it's a report. It's not been authenticated.
We gave them the notice of a business record. They did not file an objection to it. And it shows that the court may recall crime scene swab both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Ms. Benefield testified on the stand that she attempted to flee the house. Mr. Benefield ran after her, grabbed her, spun her around, and blocked the door so she couldn't get out.
Yeah, but it's okay. Go ahead.
My objections are not to the business record certification, Judge. My objection is the contents of the report there has not been a foundation laid to make that report relevant. There has not been a witness that testified that swabs were taken and then turned over. There was not a witness that said, I'm speaking. There's not a witness who says that those swabs were taken from Ashley Benefield and then those swabs were sent to DNA labs. So anything contained in that report that says there's DNA from Doug Benefield or Ashley Benefield is hearsay. There is not a person at DNA labs that can say where those swabs came from. They all they know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report. And the report, there's no witness here to testify to explain a very complicated report. This isn't, even ballistics is somewhat simple. This is DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay. There's an insufficient foundation to enter this, and that there's a unfair prejudice.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashley Benefield's hands, arms, and forearms for DNA evidence, and I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren. Now I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it along with the business certification records of the custodian.
I've seen plenty of them. All right, anything else?
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashley Benefield. There's been no witness that said, these are the same swabs that were sent to DNA labs. There's been no witness that said, those are the swabs I received. There's been no establishment that anything in that report is related to this case based on anything other than hearsay, which, I'm sorry, Judge, I already said all those things, but it's just frustrating because all the steps to get that reported under certified business records have been skipped. And so, although I don't object to that portion of it, it's the contents being hearsay and improper.
As a proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. We gave them notice plenty of time.
That's not my
Yeah, this is a really easy call. that lab report is not admissible, you could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence. After the chain of custody has been established, there's been no evidence, I haven't heard anything at all about the I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then, of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be prohibited, crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant, and you can ask him. I think if that's his supplemental report, I think it's close, but I'll let you ask him. Here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about, and aren't solely to impeach. So, all right, let's.
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's leading this witness and speaking what's on the report before the witness even says he wrote it or anything. So I would prefer that he
establish if it's his report. Establish that down on right here. There's a box that says a bias. What does that mean to you? And he left it blank. And is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So. Let's bring it back in. All right, sir. Did you speak with anybody about your testimony, or did anybody approach you to speak with you? Did you talk with other witnesses about their testimony, or the questions asked of them?
No, sir.
Do any research on the case? Watch it at all?
No, sir.
All right, let's go and bring the jury in. All right, you all can have a seat. Welcome back, everybody. Did you begin deliberating? amongst yourselves, talk with anybody outside the jury about the case, or do any research on people, places, things, or legal topics. Everybody says no, you may resume your direct exam.
Thank you. Detective Warren, did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
What's the date?
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
Yeah, you documented it in your report, did you not?
Yes, sir.
All right, my last question, Detective. Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. May I look at it just to verify?
Sure.
Okay.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
Okay.
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
This section that says bias, isn't this for hate crimes?
Yes, ma'am. When we fill out certain areas for certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box.
Okay.
But
So this box is for those kind of statistics, not for any kind of bias that may be going on in this case?
correct.
Thank you.
Redirect.
Do you think it odd that you're the lead detective in this case and
Objection
you weren't called
beyond
by
the
the
scope.
state?
Sustained.
No further, nothing further.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions I gave you about sequestration remain in force.
Do I need to stay in the building, or can I leave?
No, sir, you can go, but you
Okay.
need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
Call your next witness.
try to come back to it. We call Dr. We call Michael Haig.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thanks, sir.
Yes, sir. Appreciate it. My name is Judge Ryder, presiding. Go ahead. Make yourself comfortable in that chair. Get about 12 to 15 inches from that microphone. You just up, down, left, right. There you go. And just speak in a loud, clear voice. It'll pick up everything. Thanks, sir.
Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haig, H-A-A-G.
What type of work do you do, Mr. Haig?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a Bachelor's of Science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haig, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug. So after I went to college and got my degree, I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taking classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt, if you need to spell it. Bundeskriminalamt, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Tool Mark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFSI is one that I'm
I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically reviewed, peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Toolmark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haig, any forensic presentations of note?
I very regularly present, both at conferences as well as for organizations, on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which a certification applies to an individual, an accreditation applies to a laboratory, so those are terms you'll often hear mixed, but certifications available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as toolmark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTI ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California, Texas, and Rhode Island, and I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial. I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts. I've worked cases from Iraq and many other places that I lose track of.
Are you an instructor in any areas of forensics?
I am.
You've written on the subject as well?
I have.
And you provide regular training in shooting reconstruction?
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So this is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself. It could involve trajectories. It can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can you describe for us what a 3D laser scanner is?
This is a tool that I actually feel very lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button. It shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene. And then you move that system from one place to the next, so you can move around corners, and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005, and since then many departments have also seen the value of it, particularly with trajectories in my opinion, and it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course, and so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident, and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that could be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, It can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and that I've lectured on at the Swiss Wound Ballistics workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines as documented. They give us an idea of where a firearm may have been at the time a shot was fired based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are. About plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets?
Correct.
All right. And this information that was provided to you was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today.
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right, let me ask you with that preface to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand, in a way, where they'd been. This is sort of one of my main areas of interest, is the damage to projectiles, sometimes, depending on their condition when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels when it encounters something liquid and expands. Some people like the term mushroom. I don't prefer that term. But when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down, and around. But it leaves you with a forward-facing area of the projectile that's greater than the original caliber. In mushrooms, you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo or are created through intense engineering by people at the companies such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to, say, the range, would be to control penetration depth. So this bullet will stay in one body, and you don't over-penetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see over-penetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haig, recovered?
From my review, there were 4 fired cartridge casings and 4 projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings into play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So, for example, 1 bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, in my examination, shows soft damage, expansion, just as I would expect from bullets of this type. That bullet's wound path in the torso is well documented, and so we can kind of take 1 of 4 off the table in that the entrance hole, primarily for me in the shirt, is a nice round hole indicating that it was not unstable tumbling before it got there. This is basically a nice stable bullet entry, and that bullet was recovered there, so that's 1 of 4. Another bullet was recovered after going through one of the walls of the bedroom and through several cabinets into a bathroom area. And under examination, when I looked at that bullet, it initially looked mushroomed, which is why I'm not a fan of that term, because it had the visual appearance of it, but it was just deformed. Instead of the jacketing material unfolding as I described before, how bullets do in tissue, it was just collapsed. So if you see pictures of this bullet, which, as I recall, this is bullet number 11 in the crime scene images, I believe, while it looks fairly mushroomed, it does not demonstrate soft damage, and the hole going into the bedroom wall is, again, a nice round hole, indicating that that bullet was stable when it struck the wall, had not struck something else first. So that's 2 of our 4 bullets that are sort of off the table, and we kind of know somewhat what their story is. A third bullet was recovered down a hallway from the bedroom and in a wall. And other crime scene images indicate that it had gone through things like a book, I believe a part of a mattress, and maybe a book holder before it got to the wall where it was recovered. Examination of this bullet was very interesting in that it shows no signs of any sort of soft damage or even mushrooming of the nose. The nose is in its basically initial condition, but it has a very classic and typical characteristic to it that I demonstrate in my recon class when I ricochet bullets off materials at shallow angles. So when I say ricochet, I mean the bullet came in at a shallow angle and continued on along its path. It's a flat spot on the ogive is the part of the bullet we're going to talk about. It's the rounded part from the nose down towards what's called the bearing surface or the cylindrical portion of the bullet. So it's a big flat spot because things like tile, what we describe as unyielding surfaces, meaning they don't give, the bullet takes up the damage, create those flat spots. In addition to that, when you look at the flat spot, you see scratches or stria on it from dynamic interaction with the surface, and those lines go straight from the nose to the base. That tells me this bullet, when it struck tile, is the likely thing in this scenario, the floor, it was stable, it was going nose first to get that flat spot and be scratched directly from the nose to the base. It then continued on downrange and was stuck in the wall. That bullet gives us some idea of some trajectory, even though it's stuck in a wall just barely. You can, in the crime scene images, see it stuck in the soft drywall, because it's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is, but that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area, so we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our fourth bullet is found on the floor in the bedroom, in the middle of the floor. Its position to me does not really mean much because it's laying there just on the floor where it could have been kicked, could have been moved slightly, so we don't know where else it might have struck in that room. But the key thing about this bullet, and this is bullet number 5 as I recall, is that it does show soft damage. It is expanded. In the images you would see the jacketing material is peeled directly back and is facing rearward. The damage to this bullet tells me it went through tissue, something soft and liquidy, not things like wood and drywall or glass, but rather tissue. In this case is our limited universe option. So this bullet, number 5, would have had to have gone through the gunshot wound to the leg, which as I recall enters on the inter left portion of the leg and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike.
When you speak of tissue, we're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have 2 things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right. Before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullets were covered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue. If you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time that shot was fired. Again, that snapshot in time.
Are you able to reach any conclusion with respect to the order of the shots?
There's nothing in this from the physical evidence standpoint that allows me to sequence these shots 1 through 4. If one starts to make assumptions, which some people recoil at the word assumption, as long as you have a legitimate reason for saying the word assumption or are willing to describe its validity, we make assumptions in science all the time. It allows us to make further steps. So, for example, we have 2 trajectories through the body. We have 2 trajectories into objects into the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway, and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom, and we look at those 2 trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those 2 shots. I can't tell you with regard to sequencing, which one was first. But if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right. That's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those two trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body, but because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident or otherwise, if we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the two trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically two relatively opposing trajectories on an object that undeniably, in my work, objects, bodies, regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before, with the two trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because, again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left at those shots. A statement of such would be supported by those two trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up the laptop.
Yes.
Yes, please, Your Honor. Thank you.
What I'm showing you here is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we see on the screen. So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom, over the top of the room.
Mr. Haig, I'm sorry to interrupt.
Please.
This is the room where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall?
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room. Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11 maybe, but if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there's an impact site in the wall right here. That's where a bullet hole exists. From that, I took 2 different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line that comes out of that, and I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view. So looking at this trajectory, you see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did 2 different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room, so the bottom wall as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that, so green and blue. In the trajectory world with walls, this is decent agreement between these 2 methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5 degree cones, I talked about the error earlier, on both of these, we can see that those 2 cones look like that. That's actually a 10 degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down. And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Ms. Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Hagan,
yeah.
as to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent. If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, there, they'll fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
And that's another bullet, is that correct?
correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct. But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Okay. Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that, Turf, just that plus or minus 5 degrees is an industry standard, and based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Haig, in preparation for your responsibilities in this case to interview Ms. Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Yes, sir.
That's all, Your Honor. Thank you, Mr. Hague.
Ross?
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the 2 shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body,
Straight.
Oh, this way?
right, can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes, I'd have no way of, yeah,
Thank
correct,
you.
yeah.
Thank you, no further questions.
Redirect?
No, sir.
Can this witness be released?
Yes.
Yes.
Sir, you're releasing your subpoena, you're free to go.
Thanks, sir.
Thank you. It's going to take him a minute to put that away, and it's about 10 minutes after 3, so I'm going to give you your afternoon break. Give you 10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it, and we'll get you back out here as soon as we can. Oh, no deliberations, don't talk with anybody about the case, and don't do any research. All right? Figured that'd be better than having you.
Hustle. Thanks, sir. Appreciate it.
All right, we'll stay to recess for 10 minutes.
Thank you.
I'm not sure which one that was on. I think it was on
On the
young Mr. Galvano.
yes.
So we might use him as a
Yep.
exhibit. And who's this last witness going to be?
This is Dr. Emma Liu, Your Honor, L-E-W.
Well, don't bring her in yet. I was just asking. While we're on the subject, how long do you think she's going to be? More than an hour?
Probably not. I would say maybe 45 minutes, my best guess.
No problem. I just versus 4 hours.
Correct.
All right.
No problem.
State, have you already deposed her?
Yes.
All right. So you know
Yes.
she's going to say,
Yes.
presumably what your question is going to be.
Yes.
I only ask because that will take us, assuming we start in the next 5 or 10 minutes, 5 minutes, to 4:20, and I guess at that point probably let the jury go for the evening. Well, you can announce you rest. We can let the jury go for the evening. You guys can say if you're going to call any rebuttal or not, but then maybe one pass through the jury instructions. I'd appreciate that.
So would I.
Okay.
Judge, the last thing the state wants to bring up is that we didn't bring it up during the question, but I think that Your Honor had clearly told Mr. Taylor at the bench what he was allowed to ask Detective Warren, and that did not include, don't you find it odd that the state did not call you as a witness? And I think we had litigated close to that issue, if not directly on point, and then you directed him not to. And I know we're down to a few witnesses left, but it's been an ongoing attempt to subvert justice by Mr. Taylor to continue to do things like that, speaking when we've objected and continuing to speak. And as to the don't you think it's odd, it was actually Mr. O'Keefe who told Mr. Taylor, hey, you need to object to this. So that's a whole different objection I have, that Mr. O'Keefe continues to practice law in this courtroom. But I just think that at this point, the state is asking for you to sanction Mr. Taylor in some capacity about disregarding your continued rulings. And I understand that that may not be something we address right now, but it seems to be an ongoing issue in the state. That last one with Detective Warren was the most outrageous.
Okay. I'm not going to take that matter up right now.
Yes.
We got witnesses and other matters to deal with, so.
I just wanted to get it on the record before we move too far away from the witness. Thank you for letting me be heard.
Absolutely. All right, looks like we've got everybody back. Is Dr. Liu ready?
Yes, sir.
State, are you ready?
Yes, Judge. Thank you.
We'll do that right now.
All right. We'll bring him in. Do you need the?
I don't think so, Judge.
All right, y'all can have a seat. Welcome back, everybody. Any deliberations, contact outside the jury about the case, or research? Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Dr. Emma Wu.
Case in first, raise your right hand this morning.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Doctor. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just speak in a loud, clear voice. It does adjust up, down, left, right if you need it.
Yes, thank you, Your Honor.
Good afternoon.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Liu. Let's take a moment. Let me just run you through your undergraduate education. Where
Yes.
did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Liu?
I wanted to train in the best facility that there was for forensic pathology, and everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Liu, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Lines security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
And how about gunshot wounds? Have you taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. If you'd be kind enough, would you explain to us, Dr. Liu, what is an autopsy?
An autopsy is the examination of a dead body. It consists of two parts. One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination, and that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Dr. Liu, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Liu, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm, and that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega, but as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And was there another gunshot wound?
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple.
Please do.
And yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right fifth rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through-and-through gunshot wound, or what we call a perforating gunshot wound, that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you a picture and have you explain to the ladies and gentlemen of the jury, you mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay, so how, Dr. Liu, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Liu could step down. I wonder if we could have the easel so I could set these up. Dr. Liu, here is a pointer that will help you. Good.
State, feel free to reposition as you need so you can see what's going on.
Thank you.
With court's permission,
Yes,
I
ma'am, you
ask
can step
Dr.
down.
Liu to
Thank
step
you.
down.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have a preference of which one you'd like to start with? Okay, with this one. All right, would you tell us what that represents, Dr. Liu?
This is the graze or superficial gunshot wound on the outside of the right upper arm. I know there's a
Yes, a rod.
point, a rod on the use.
We have three.
Now, the reason I know that this is a graze gunshot wound is, from training and experience. Now, the direction of this projectile, you see this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here, for example. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. See this V-shaped tag? And for simplicity, how I remember pathways of graze wounds is that the skin tags point toward the gun. So, if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back. Going from front to back and upward. And because it's on this part of the arm, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
If I may.
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because the back portion that's straight was an incision made by the doctors in the hospital. So the gunshot wound itself is this round part. Now this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back.
Now, there's something special about this gunshot wound that Dr. Vega may have told you already. After going through the nicking the right fifth rib and the right lower lobe of lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord, the energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this wound will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord shock. And the result is paralysis of the legs. I know because I've had cases like this where a bullet not even going through the bone of the spine, just passes by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this gunshot.
All right. I think you can probably return to your seat if you like. Does it have some water in it?
It does. It's too complex for me.
Let me see if I can help.
Not too much. It's me. Probably the right there in case you need.
Dr. Liu, did you have an opportunity prior to your testifying here today to meet and observe and listen to Ms. Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Ms. Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
At the time that you observed Ms. Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic
Hearsay,
evidence?
If she can answer without speculating.
I do not know, however, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection relevance.
I'll sustain.
One last question, Dr. Liu, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times, and then maybe 20-some times more after I retired.
And the vast majority of those occasions, Did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Liu. Give me just a moment, Your Honor. Dr. Liu, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by the deceased?
I believe it would add a new dimension to my testimony. Yes.
Okay. Judge, with your permission, may I?
Yes.
Come on up, Will.
May I step down, Your Honor?
Yes, ma'am, please do.
May Dr. Liu step down?
Now, I believe that the Gray's gunshot wound was the first gunshot wound because Ms. Benefield indicated that Mr. Benefield was coming towards her.
Objection, Judge.
I'm going to sustain.
Go ahead, Dr. Liu. You just can't say what Ms. Benefield told you,
Okay.
just based upon your conclusions.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
Dr. Liu, without regard to anything that Ms. Benefield may have said that you heard, based upon your expertise and your own conclusions that you reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm Gray's gunshot wound was the first shot.
Are you able to say why? What independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it is just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection. Objection. Lack of knowledge.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now, you've told us, Dr. Liu, about the shock to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Please.
The right side facing the
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
The right side facing
Judge, I'm confused as to what we're demonstrating.
We're demonstrating the shot to the leg.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand and reposition yourself.
Now, the entrance was on the right side of the entrance was on the right side of the back of the cab, and the exit was here. Now, you can see that the gun would be somewhere along here. So you can see how consistent this pathway would be from getting shot while he's on the ground, with the gun being in this position. So it's going in here and coming out here.
Okay, so this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Liu, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
The evidence on the body, which consists of those gunshot wounds, is consistent with that.
All right, thank you very much. Thank you, Will. I have one last question for you, Dr. Liu. You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Liu. I have no further questions, Your Honor.
I just want to ask you about the leg wound.
Yes.
For a moment. You're not saying that that is the only position that he could have been in? Are
No,
you?
I am not saying that.
Okay. So there are other positions that maybe could have produced that wound path?
Yes.
Okay. The one that you are describing is just one that is consistent with it.
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked maybe?
Yes.
Concussed? I don't know what you said. And his legs would go paralyzed.
Yes.
Does that normally mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay. So depending on maybe what movement they're doing at the time, that's what they're going to continue to do.
Possibly,
So,
yes.
Possibly. So if he is walking towards someone, would he fall backwards with paralyzed legs?
Well,
We weren't there, so I don't know exactly his body positioning and movements.
Okay. And you spoke about the abraded contusion on the head, and that can be consistent with falling
Yes.
from a gunshot. Can it also be consistent with being drug out of the house by EMTs?
Not unless that part of the head were to be struck on something, because the contusion is a bruise which requires blunt force.
Right. So if, for instance, he was being drug out and hit the door jamb or something, bounced his head, could it have caused that kind of abraded contusion on the head?
Well, done with enough force, that is possible.
Okay. Thank you. No further questions.
Direct.
One. Dr. Liu, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
Do you have any questions on that?
No.
All right, can this witness be released? Can the witness be released?
Yes, sir.
State? Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much. All right, Mr. Taylor?
We have this one issue left.
Okay. All right, members of the jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues. We'll get you right back as soon as we can. Okay, oh, you all can have a seat. The jury's out. And was this the issue, the Richardson?
No, this is the DNA issue.
Oh, yes.
And I have the following case for the court. Ladies,
Thank you.
ma'am.
Yes, sir. All right. Go ahead, sir. I've had a chance to review shorter.
Okay, so this was a DNA report, precisely what the circumstances are here. The state initially wanted to introduce it, but then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So we think that the shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
Judge, I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. That the fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in proper evidence. That's all. We don't have any evidence that the same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections, because my objections are what I've already stated, but also 403, with just that lab report in evidence. This is very confusing. It's DNA. And it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swabs came from, all those things, and I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation, and that they're confusing.
Sure. In rebuttal?
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Dorvac testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any. Chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these two sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International. It actually, it's a letter or report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office. And it is signed by Jerome Rem, R-E-M-M, Forensic DNA Analyst. It lists a number of items . 14 different items that were apparently sent to DNA labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880. swab from suspect's right hand. And it says that the testing was done. Mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile. And it gives, based on its testing, 2 different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and 2 unknown persons contributed to the profile rather than Ashley Benefield and 3 unknown persons.
So now I'm asking you that next sentence.
I am. I'm reading it as I go.
Okay, thanks, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashley Benefield and 3 unknown persons than if it originated from Ashley Benefield, John Sant, and 2 unknown persons. Therefore, there is extremely strong support that Ashley Benefield and 3 unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and 2 unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab, and the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody the chance to argue.
Sorry.
So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the fourth DCA, it says so in the very next paragraph, the reason the fourth DCA upheld the admission was for that very reason, that the state did not argue 403. And here they are. Here the state has argued the 403 for a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says, and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then, what does it mean, the very strong support?
That is.
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said two sentences. Yeah, these two sentences that are highlighted.
Correct.
But that's only one of the two sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in.
Can I make my record?
It would, if it would, so, no, sir. Based upon the request that's before me, which is only to put in and read into evidence these two sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes.
As a proffer?
I'd like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
It's 29, but this is the whole record.
Hold on, you're handing me a stack of paper that's about, what, an inch and a half tall?
Yes.
And the only thing you said you were gonna enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those 2 sentences. This is the full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29. What, is this in here, or does this go in here?
Yeah, no, that I believe is in there. This comes back. Oh, I'm sorry, Ron, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
Right. Can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
Beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay, so unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence, in this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Miss Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Miss Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. Now, maybe I misunderstand this, Your Honor, but to me what that says is there's 720,000 times more probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
All right, thank you. Where do you want that right after the first page?
You can put it right on top, Your Honor.
It'll cover up the exhibit number then.
Oh, okay. Yeah,
So I'm just putting it right behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the 4th DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that, then we will rest.
All right, well, there's, Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect, it was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
So do you have a...
We'll rest.
Okay. Let me bring the jury in. I will, we can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with a 9 o'clock start.
Yes, sir.
Just so you know also, we had submitted, the court may recall, requested copies of the proposed homicide charge. And we had submitted our version to you that we thought would be appropriate. And I did not save a copy of it, so I don't know if the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
Welcome back, everybody. Y'all can have a seat. All right, did anybody have any deliberations, talk with anybody outside the jury, or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor, Ms. Benefield has no further witnesses, and we rest on her behalf.
All right, sir. Folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries, or do you know? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out, and we'll have the deputies come down and get you as soon as we're ready and bring you up and get started.
Yes, sir.
All right, remember the rules for tonight? Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics.
Thank you.
Thank you. Have a good evening. Oh, you all can have a seat. All right, I'm going to have to give you all, let me give you guys a 5-minute break. I'm going to go upstairs, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can
I had
find.
it clipped.
Yeah, it was.
Yeah.
Yes.
And I have the state's proposed jury instructions and the standard for self-defense because it changed in May, and I just wanted to include it in case we need
So
to.
you got the new one.
Yes.
All right.
But I brought the standard because the instructions are very different than they used to be, so I just brought an extra copy so we could go through
And
it.
you get an extra copy for.
Yes.
All right. So 5 minutes. I'll be right back down as soon as I check.
Thank you. This is the,
You can have a seat, please.
I gave it to them, and this is the standard. I don't know if you need that, but I brought an extra copy. Okay, this is the state's proposed. If you have already a copy of ours, you can toss it because I made corrections. Okay.
And as we get started again, I was able to find the jury instructions the defense had handed up to me in the past, and I've had my judicial assistant run a copy and gave them back to the defense. And I think you had also given me this case, Gonzalez v. State.
The name alone?
Well, let me, it looks like the handwriting that's been on a couple of your other documents. And so let me give it back to you, and it might jog your memory as to why you gave it to me.
It's not my handwriting.
Oh, we'll wait. I didn't look over.
Yeah, so actually, I remember. I think Gonzalez was our consideration and debate about whether or not we could get a charge of self-defense based exclusively on the 9/11 tape. We're a long way away from that.
All right. Do we just toss that? Or you keep it? Okay, sure.
I'm just trying to see if I have the right page.
Sorry, Madam Clerk. I was trying to hold it back.
I just wanted to see if I have the right packet.
Well, let me show you. Yeah, let me show you what I gave to the judge. Right here. Yeah. It didn't look like that.
I think it is, but you might be missing some more highlights.
So it looks like you have an updated version.
All right, Ms. Benefield is back. So we're going to take a look at jury instructions now. So make sure that
Yep.
all right, so defense, do you have a copy of the state's proposed jury instructions?
Yes, sir.
And state, do you have a copy of the defendant's proposed?
I believe we do.
And then I have mine that I did separately. If we could, I'd like to start with the state's version, and then when we get to an instruction defense that you have your own ideas or thoughts on, we'll see how we need to modify them or mesh them. So, Ms. Benefield, these jury instructions, as I've mentioned before, if I haven't, I will mention now, are very, very important. Too often, I think, people think of jury instructions kind of as an afterthought. But whenever we started this case, I had mentioned to the jury, and I say this several times, they listen to the testimony and receive evidence. They listen to the argument of counsel, and they listen to the instructions on the law by me. So this is 1/3 of what they are supposed to look at and consider. So the way that it works is, obviously, the defense has prepared some proposed jury instructions. I've got some that I've worked on, and the state has theirs. The reason I'm working from the states is that's just how we've always done it, at least in this circuit. It's generally the state prepares jury instructions. We kind of work off those. So as we go through, some of the things that I've mentioned in the past or have talked about or will talk about become much more clear when you really see the jury instructions and this is what the law is. So, Mr. Taylor, the way I do it is I'm going to, again, work from the state's version, which you have, and I'm going to call out the number. I won't read the whole thing, and just let me know in this first pass as we go through, do you have any objections, additions, corrections, or deletions to the standards? Then we can, after we go through that first pass, then we can get into some specifics.
Okay, and would that include omissions?
Yes, absolutely.
All right.
So, for example, the first one is 3.1, Introduction to Final Instructions. Any objection to that one?
No.
All right, so that's good. Looks standard. 3.2, Statement of the Charge. Any objection, correction, addition, deletions to that one?
No.
All right, looks fine. Now, 7.1, Introduction to Homicide. That is one of the ones that you provided to me.
And I think it's just the standard. Mr. Taylor, is it just the standard that you provided, or is there a difference?
No, I provided in my packet that I provided the court with, I provided the standard.
Okay. So there's no, I just wanted to see if there was a disagreement, because ours should be the standard as well.
So if you look at the...
But mine was not edited.
Understood. No, I see that. Yes, right. You just gave me, the actual printout that I look at from the Florida Supreme Court website. But so as you look at 7.1 as proposed by the state, do you have any objections to it?
Judge, the problem that I'm having with this is I haven't had time really to review this, so I can give the court an answer off the top of my head, but I don't know how I'm supposed to check for a misprint or a word that's been omitted.
I see what you're saying. This is why I call this my first pass. It's really a 30,000-foot overview. It's not uncommon. Right at the end, what you'll find is I have this thing about Oxford commas, and I think they need to be used. I don't understand not using them, but so there's quite a few places where we're adding commas and so forth.
Yeah.
Please don't worry about those kind of details. I'm just talking in general, and this is one, quite frankly, we can skip if you prefer. You want more time to take a look at it. That's absolutely fine.
No, with that explanation, then no objection.
I can tell you, it's standard other than we added the charge and the name.
But if you see any typos or anything overnight, just let us know.
Yeah.
All right, the next one is 7.4, murder in the second degree.
And the yellow were things I didn't know if they would be applicable, so just so we make sure we didn't.
I think as I look at this overall, it looks like you've got just the standard in there. It looks okay. The issue is going to be if you all want that highlighted portion, if you want the sudden provocation. And I don't need a final answer now. It's highlighted, so you'll be able to let us know if you want that or don't want that.
Okay.
It's in there for now. Possession of a firearm and discharge causing death, 3.3D should just be the standard 1020 life instruction. All right, 3.3D looks right to me. And in fact, the one that I have from the defense, page 7 of 28,
Yep.
except for typeface, looks exactly the same. 3.4 lessers. So this is page 8 of 28 on the defense.
I believe that's the right statement as to the introduction of the lesser.
You don't have to stand. If you want to, that's fine, but
However, it's our position there should not be any lesser.
right. So are you prepared to make that argument now, or do you want to wait? It's up to you.
I think I can probably make it now, perhaps with the court giving me consideration that if I think of something overnight, I might be able to supplement.
That's fine.
So we would cite the court to the Roberts decision, State of Florida versus Geraldo Roberts at 694 Southern 2nd 825, second DCA case. It was a charge of attempted second-degree murder, aggravated assault, discharge of firearm from a vehicle, and carrying a concealed firearm. Reversed for the trial court's failure to give an instruction on attempted manslaughter and on definitions of justifiable and excusable homicide. But there is the statement made as follows. The trial court must instruct the jury completely on all necessarily included offenses, regardless of whether the facts of the case support the instruction. In this case, the trial court was required to give an instruction on attempted manslaughter and on the definitions of justifiable, excusable homicide. Trial court's failure to give the instructions is fundamental error and can be considered on appeal even though defense counsel did not object. And then they cite Rinaldi versus State, also a second DCA decision, 614 Southern 2nd 1197. And parenthetical for what Rinaldi stands for is conviction for second-degree murder reversed because the trial court's failure to include definition of justifiable homicide as part of manslaughter instruction, even though defendant failed to object. They say this then at that point: the only exception to this rule is if defense counsel affirmatively agrees to the omission or alteration of the instruction. So, on behalf of Ashley Benefield, we request no lesser included offenses. We think this is an all or none plea. She either is guilty of second degree murder or she's not guilty.
State, do you want to be heard?
Just that we disagree, it's a category 1 lesser and the state's asking to include it.
Okay. For right now, I'm going to tentatively say leave it in. But again, you want to look at some stuff? No, I'm familiar with the case though. Yes, sir. I'm very aware of those. You wanted some more time to look and see if you could find anything. So
if I
that's fine.
come up with anything else.
Leave it in for now. And as I look at manslaughter, it does look correct.
It appears the manslaughter instruction appears correct to me. However, I'm just not sure about the applicability of the various subsections at this point.
All right, and then 3.3A, the next page is the aggravation for the. I'm sorry, did you say give you a minute?
Yeah.
Oh, yeah, of course.
Yeah, no, I think it's.
Oh, all right. Yeah, 3.3A looks like the standard. All right. Justifiable use of deadly force.
Excuse the boldness, Judge, I just don't think he got that far without fixing it.
All right. I'm looking across 3 different pages here. Yes. All right, so here's, are you on 3.6F?
Yep.
All right, so here's going to become the first issue. Right about the middle of the page, Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent, of course we know there's 2. I'm sure you want A, imminent death or great bodily harm to herself.
Yeah.
Are you also asking for an instruction on the forcible felony?
Absolutely.
And I saw that towards the end of your paperwork. And it looks like you're asking for, you see that state towards the back of their packet? It looks like you're asking for burglary, felony bat, ag bat, ag assault, false imprisonment, that looks like all of them.
Burglary.
Yes, yeah, I started with that one. I actually went from back to front, so
Oh, okay.
burglary, felony bat, ag assault, and false imprisonment.
I believe that's correct.
Sure. I'm maybe misunderstanding. Is counsel asking for all of those felonies to be included?
I think that's your starting point.
Yes.
All right, state, let's start off easy and ask, are there any of those forcible felonies that you agree with the court instructing the jury?
Before we get there, Judge, on the standard I gave you, can you read the sentence right before this paragraph? And it says the law on justifiable use of deadly force is as follows. And then it says, give if the defendant is relying on 776.0122 or 776.0312, but not relying on 776.0131. So it seems like now you're supposed to pick, because it is repetitive. Because that same language is in each section.
All right, 776.0122. It appears, I would say, that the defense is relying on 776.012, subsection 2. That's the self-defensive person.
It's the second part of that sentence. It says, but not relying on 776.031 and 013. And I believe they are relying on 776.013.
All right, that's protection in the home. All right, do you see what the state's saying?
Yes, I do. This is a rather unique factual situation. I'm not sure at this point I have an answer for the court.
All right, I'll outline it, and let me just say that having served on many rules committees in the past and currently serving on a rule committee, it is yeoman's work what they do, and I can only imagine how many hours went into the criminal jury instruction committee putting 3.6F and 3.6G together. And I know sometimes we will fuss, or I will fuss, at the complicated nature of these jury instructions, but they really are good, and I appreciate the work of the committee. So to put it simply, on the standard jury instruction, from the part of give if defendant is relying on 776.012 sub 2 or 776031 sub 2, but is not relying on 776013.1. Because 776013.1, as we know, gives even greater protections or establishes and explains the castle doctrine, from which Stand Your Ground expanded that castle doctrine out into other places. But I think what the jury instructions are saying in interpreting the case law is that if the defendant is relying in part on that home protection, 776013 subsection 1, a person who is in a dwelling or residence in which the person has a right to be, has no duty to retreat, and has the right to stand her ground and use or threaten to use, and then A, non-deadly, and B, deadly. And the reason that that distinction is made in these jury instructions is because if you're not, you automatically get those protections in the home, right? But 776012 is more of the general use or threatened use of force in defense of a person. And in that situation, the additional information that because it's not in the residence, the jury has to be instructed on the duty to retreat, or the non-duty to retreat, and a right to stand your ground if the person using or threatening to use deadly force is not engaged in criminal activity and is in a place where he or she has a right to be. Obviously, because 776013 is in the home, which Ms. Benefield was, would lend itself to the argument being made by the state that we would not have the first part of the standard, but we would skip down to give if defendant is relying on 776013 subsection 1, self-defense in the home, because it has all the same things, except now you're in your home, so the jury does not have to consider that you, whether or not you're engaged in criminal activity or whether or not you're in a place where you have a right to be, because you are.
Judge, what is 0312?
0132?
No, 7760312. It says, give it
That's defensive property.
property.
Yeah.
I remember putting the instructions together, but I didn't remember what the substance was.
So I think, and of course, it's imminent death or great bodily harm to herself, or the imminent commission of the forcible felonies, and we still have to, once we determine which forcible felonies we're going to give. So
Okay.
that's just me putting that on the record for future reference, posterity's sake. All right, the next one is.
So are we taking that first part out?
Well, I'm just putting
Okay.
what my interpretation is of these jury instructions and why I think ultimately we're going to give the second one, 776013 sub 1, as opposed to 776012 2.
Yes.
I don't think we've had any arguments about necessarily 782.02. Essentially, 782.02 is essentially a restatement of what we would cover under 776.013 sub 1. I think it's kind of duplicative, and I'm sure each side will have their own arguments.
Judge, I think just for timing, I think we're going to be closing early tomorrow. So I don't know that we're going to have a lot of time to, you know what I mean?
I understand.
Okay.
I was going to ask the court, you already announced that we could close in the afternoon, so we'd be able to clean this up.
I'll just say that I was kind of leaning that way. That whatever rebuttal you want to do, cut them loose. And then whatever, we still got a end of the road JOA, if you want to make one.
Yeah.
And then I figure that's it. Now we know what evidence is in. We can put the final touches on everything. You'll have had this evening and tomorrow morning to look at these issues and get them finalized. Then you guys make the copies for us. I usually ask the state to make all the copies with and without verdict forms and so forth. And then come back in the afternoon, give them an early lunch. But if we send them away early, we can have them back at 1 o'clock, 12:30, whatever we want, to give you guys time to do your closings.
I don't anticipate rebuttal's going to be very long.
How much time do you think you're going to want to ask for closing?
First and second together,
Yes, total.
probably an hour and a half to be safe.
Mr. Taylor?
I'll take that, but I doubt that I'll use that.
Yeah, I don't know that I will either.
So I'm glad you asked about timing. Yeah, I think you're right. That's probably what it's looking like. We'll be here first thing in the morning. Any rebuttal, then rest, and then I'll let them go and tell them to be back, whatever makes sense, 12:30, 1 o'clock. Then we'll come back. Then we'll stay, get all the jury instructions done. When they come back, we'll go.
Do we want to find out what the rebuttal is so we can make any argument if we have it before the jury comes in?
Yes, absolutely. Yeah, but let's cover that in the morning.
Okay.
All right, so we were on the 782.02. I'll let you guys argue, but I think that that might be duplicative of what the instruction that's already going to be given from 776.013 sub 1. And then the next paragraph, in deciding, that certainly needs to be in there. Oh, that's where we left off. Were there any of those forcible felonies that you're prepared to agree with right now? That way it'll limit what I have to hear argument on.
And I just wanted to make sure I got them all. They were burglary, aggravated assault, aggravated battery,
Felony bat
felony bat.
and false imprisonment.
I thought I heard false imprisonment. I don't think I have that one, but okay.
Yeah, it should be in my package, Suzanne.
It might be, but I just couldn't find it. And Judge, to be honest with you, I've never had more than one felony read, so I don't quite know how to respond.
Yeah.
Typically, the defense will focus in on what they say the crime is and move forward from there, but
Well, you guys both know it's only the elements, right? The crime of burglary is the crime of felony battery, just the elements.
Well, we would need for this case in the burglary instruction to them that a remaining in burglary is the equivalent. Remaining in improperly.
Understood.
And Judge, I think remaining in improperly with the intent to commit a crime kind of covers a lot of the other crimes. So
I don't know if we can agree, because I don't think that I don't think that there is evidence that has come in of felony battery, aggravated assault. And then false imprisonment, I'd have to go back and read, but that one we may have evidence of that. And then of the burglary, I'm not sure, because I don't know what the evidence came in to commit a crime therein. state to commit a crime therein, but I need to think through it. But I can say that I would almost guarantee we'll be objecting to ag assault, ag bat, and felony battery.
All right, so be prepared for that. I'm not saying you need to commit to it now. I want you both to be able to go back to your offices this evening. This is why I do this big overview. That way you guys can go back. You've already heard a little bit of each other's thoughts. Nobody's locked in. But then you can go back tomorrow loaded for bear. All right. Presumption of fear.
Presumption of fear.
Yeah, the 776013 sub 2.
I don't think this comes in because it's forcible entry into a dwelling, and I don't think there's any evidence of unlawful and forcible entry into a dwelling.
Yeah, I think I'm inclined to agree with that.
I think so. So that would be out.
And I think thereby the next section will be out too.
Yeah, which is the presumption does not apply if. So it's both ways. The presumption applies if and does not apply if. I think that can all be out. And then that last portion too, because it's all talking about by force.
And Judge, just so I'm sure that we're on the same page, that's the part that starts 776.0134.
Yes, ma'am.
Okay, thank you.
So the next part about 776041, there's certainly, it's only the one charge. There's no other forcible felonies.
And I think we can take vehicle out right above that too. The safety's sake. But yes, I don't think any of this next part comes in.
Right, there's been, and I don't expect any evidence that the defendant was attempting to committing or escaping after the commission of some other forcible felony.
Correct.
And so I think that's all out. State the next one regarding aggressor, and whenever the defendant, there's some evidence where the defendant was the main or initial aggressor, and then the force comes back when the defendant would be justified in using force when they were the aggressor.
I don't think there's any evidence.
I don't either.
I'd already crossed it out, sorry.
Okay, is that all right? I don't recall any evidence that Ms. Benefield was the initial or main aggressor.
It's down at the bottom of the page. It says aggressor, and then it says Gibbs v. State right above it.
Yes, okay.
All right. So that will be out. The next part is absolutely in.
Yes, I think the next two parts are.
The thrust of the defense.
Yes.
So prior threats is in. However, the reputation, I don't think there was any testimony regarding reputation of the victim.
Agreed.
So the next two would come out.
Yeah.
And then the physical abilities is in all.
I'm sorry?
The last one's in everything. It's reading all cases, the physical abilities.
Yeah, physical abilities
Yes.
is in.
Absolutely.
And I will fix these tonight and probably email them tonight or tomorrow once they're all
If you would, that would be great. I'd appreciate that. All right, so see, this is why I do this kind of general overview, so at least we can figure out where the touch points are for disagreement. All right, that's 3.6F. We're not giving 3.6G. right?
Sorry.
Use of non-deadly force. Everybody agrees.
Yes, yes.
Okay.
Sorry, I got confused.
No, I just want to make sure because there's some cases out there that talk about both of them. You give one, you give the other.
I think it says now in the new standard, it said at the bottom, unless evidence establishes force or threat was deadly and non-deadly as a matter of law, and then it goes on and says the discharge of a firearm, whether accidental or not, has been deemed to be deadly force.
I'm still going to belt and suspenders it and make sure everybody's agreeing we're not giving 3.6G.
I understand.
All right. All right, so now this should be pretty quick the rest of the way. 3.7, plea of not guilty, reasonable doubt.
Yep.
All right. 3.9, weighing the evidence. Now, on this one, Ms. Benefield, of course, Mr. Taylor's has the copy right there. The 10 issues regarding credibility and factors for the jury to consider, 1 through 5 are given in virtually every case I've ever been involved in. We do 1 through 5. 6 through 10, however, really depend on the facts of the case and whether there's factual support for giving it. So 6, any evidence of 6?
No, the state doesn't
No.
believe so.
All right, 6 is out. 7, pressure or threat. State?
I don't think so, Judge. I think
Defense. Any argument you want to make about pressure or threat?
I don't believe so, Judge.
All right, 7 is out. 8, certainly 8 stays in because there's been some impeachment. So 8 becomes 6. 9, I haven't heard, there's been no conviction,
9 and
impeachment.
10 are out.
All right, don't expect any of that. And 10, we don't expect any reputation for truthfulness or honesty?
No.
All right. So it looks like 8 becomes 6, and that one will be good.
And then I just need to unhighlight the defendant. I always highlight
Right.
that next part until we figure it out.
So, yeah, page 2 of that is going to be unhighlighted, but needs to be given. The defendant has become a witness. And so, oh, you already took out 3.9A?
I did.
Okay.
We fixed them last night.
All right.
We could.
Mr. Taylor, because this is our first trial together, at 3.9, I stop. So for the initial instructions, I go all the way through 3.9, then I stop, and then I will explain the verdict form to the jury and go over it and explain how it works. That way you don't have to use your valuable closing time explaining how the jury verdict form works. You can just get right into it.
Okay.
When we come back, I'll touch on 3.10. And that looks fine. 3.11 cautionary. That looks fine. 3.12. All right, so 3.12, when then we come back and I give the final instructions, I of course read 3.12, but down at the bottom where it says it is as follows, I just tell the jury I previously explained the jury form. All right, 3.13, submitting the case to the jury. Did you already take out the thing about questions?
Yeah, that's actually on. I think that's on rules for deliberation, which I already took it out. Is that what you took it from? But yes, I took it out.
Yeah, no, it's on 3.13.
Oh, okay, I'm sorry.
There's in 3.13, it's not in the state's version because they already took it out. There's the one paragraph in the standard that talks about questions that were asked during the trial by the jury but weren't answered. And I removed that because I don't allow jury questions. And then at the bottom, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. These exhibits will be sent into the jury room with you when you begin to deliberate. However, and it's up to you, we can craft this in here, but I usually ad lib at that point. For example, if it's a child pornography case, you got to come out and view it. If it's a CPT tape, you have to request to view it. In this situation, I would say we're going to send the firearm back with you. Is there live
There's
ammunition?
no live ammunition. We did not bring it.
Oh, okay. I thought there was.
Correct me if I'm wrong, clerk, but I believe it's all casings and expelled bullets.
So the testimony was that live rounds were found. There was a live round in the chamber and live rounds in the magazine,
Yes.
but those live rounds have not been introduced into evidence.
Correct, they were packaged separately by crime scene and we did not bring them for that reason.
All right, so with that said, everything goes back,
And I'll-
unless you guys say something different.
No, I just wanted to wait because I know because it was a firearm, but I think it should be A, not B, and I'll just make it one paragraph.
Yeah. So usually, if there's a firearm and magazines and live ammo, it's one or the other. Either you can have the firearm and the magazine, or you can have the live ammo, but I don't have that problem here. And then in closing, let me remind you, now the verdict form, aren't we going to need some special interrogatories?
Oh, yes, I'm sorry.
I was say mine is just,
It is, and I was looking at it thinking, wow, this is really short. Yes, sir, I'll fix it tonight and then we'll have to look at it tomorrow, but.
the one that we end up usually using, as you would imagine, the defendant is guilty of murder in the second degree as charged. And then underneath that are the special interrogatories for the 1020 life. Then you'll have B, the defendant is guilty of manslaughter, a lesser included offense, and there's the one interrogatory regarding actual possession of a firearm, and then C, the defendant is not guilty. So that's what it should look like. But obviously you've tried cases all over, so if there's that's the standard we use here in the 12th here in Manatee. If there's some other format that you used before you think is better, certainly willing to listen.
I'm fine with it.
All right, thank you very much for giving me that extra half hour and going over the jury instructions so we understand who's where. And if there's nothing else, Richardson, do you want to do that tonight or do you want to do that in the morning? Okay.
Judge, and I'm going to show them an exhibit I intend to introduce tomorrow, and they may have another. This did not become relevant until rebuttal. I mean, it's for rebuttal. It didn't become relevant until after the testimony.
Okay, so we have the two photographs for Richardson hearing
Yes, sir.
and the rebuttal. Apparently, the state is going to recall Eva Benefield. The court may recall it has been holding in abeyance my motion to strike her as a rebuttal witness.
Judge, and I can maybe simplify. I intend to ask her a question about this picture that I'm holding up. I intend to ask her a question about the pictures that were introduced by the defense of the gym pictures, just to ask her if she's familiar with those and when they were taken. And I also intend to ask her if her father was right or left-handed. And then that's all I intend to ask her. So I don't know that sitting in would have tainted any of those answers.
All right, can I see the picture you're
Yes.
talking about? Is there an issue? What's that one marked? What number? State?
105. 105.
Was this one disclosed?
Yeah,
You got 105 or no?
yeah, that's the photograph.
Right,
Just now, because it was not relevant to rebuttal.
that's what I'm asking.
That was not a discovery.
Okay, there we go. So we're going to include states 103, which we referred to as the modeling photo. 104 as the mugshot. And 105, I'm just going to call that one the boat picture or boat photo because they're on a boat. All right. Yes, sir.
What do you want to take up first?
How about the Richardson violation?
Yes. So, they were never provided at all in discovery. Not only were they not provided, but let's be clear, because if I've learned nothing else, I've learned this. They weren't provided in a dump at any time, so we were completely unaware of those photographs.
Can I just ask, is that argument for all three of the photographs?
Yes, we, to our knowledge, were never provided with that photograph either.
No, the reason I'm asking is because the mugshot photo was entered in the stand your ground, so I don't think that was.
Well, hold on. Let me keep some semblance of order, even though of the late hour. So, right.
I thought the mugshot's in already.
That's one of the two that we're talking about.
Yeah.
The mugshot.
So here's the three photos we're talking about for this Richardson hearing. States 103 is what we've been referring to as the modeling photo. Go ahead and pull them out. I'm so sorry, Madam Clerk. She asked if we wanted them, and I said no, and now it's probably better we do. That's 103. 104, we've been referring to that as mugshot, and 105 we're now referring to as the boat picture. And the mugshot, my notes are 103 and 104 were not admitted.
Correct, and that was just an oversight. They were published and we spoke about them, I just didn't say the words.
Correct. All right, so I have them up here if you want to review them.
And
I have them here if you want to review them.
would like to say the mugshot was disclosed in discovery. I can find the discovery page, the big fancy page if you need me to, but it was disclosed in discovery.
You can take those with you if you want.
Yeah, there was a companion photograph with this that they sought to introduce that we never got either.
No, it was that one.
Is this?
It was that one.
Yeah, just
Oh,
those two.
okay, I could have sworn there were two. Okay. So, you want me to address the wedding photograph, the modeling photograph?
Yeah, all three of
All
them.
three.
Yes, sir. You go through the Richardson factors with me on all three.
Okay. So, we believe it to be, I have no evidence to present to the court that it was intentional. We believe it to be inadvertent. However, the prejudice is substantial. And given the late hour of the introduction, we've never been advised, so we've had no opportunity to meet it. And the trial is over.
All right, State.
Judge, speaking about them individually, and I apologize, I don't know which picture the mugshot is, but that was disclosed in discovery, so there is no violation. What we call modeling photo, I believe that's actually from the ballet pictures. That picture did not become relevant until the defense's case, and the defendant testified, and also Dr. Russell testified about seeing edema and swelling, and it became very important to show before this incident and after this incident what she looked like. And I don't know how that can be of any prejudice because it's a picture of the defendant. It's not like she didn't know it existed. And I don't know how the defense would have prepared differently. So I don't think it's a violation, first of all, because it didn't become relevant, and we introduced it at the time when it became relevant. And then as to the boat picture, I have the same argument that that did not become relevant until the defense's case. So therefore, we produced it as soon as it became relevant or very close thereafter. So it was no violation to begin with.
All right. Tell me about, what is the relevance of the State's 105?
The relevance is that the defense put in pictures of the victim at the gym to show that he was all muscle bound and, to try and show. Those pictures were taken in 2018.
Which pictures?
The muscle bound pictures that the defense put in.
Okay.
That picture was taken a month before he died. He did not look like those pictures that the defense entered in 2018.
How do you know he's got a shirt on? I mean, if you look at his arm, the vein is bulging on his bicep.
To the weight, not the admissibility, Judge.
When did you become aware of State's 105?
Last night.
All right. Final thoughts to the objecting party.
Put in about Mr. Benefield, how he was built, were in May of 2020, not 18.
I don't recall that evidence coming in. The date of them?
I'm just informing the court. The representation was that they were taken in 2018, and we're telling the court they were taken in May of 2020.
All right. And just so you all know, and what I'm saying to that is, as someone who hasn't been involved in this case as long as you guys have been, and don't know all the details of it, I don't recall that testimony when the photographs were put in. I don't think the date of them was established.
I'm just correcting the representation that they were May of 2018. I'm telling the court they were from May of 2020.
All right, thank you both very much. So in a Richardson hearing, obviously we talked about it before. The issue is whether it's willful or inadvertent, trivial or substantial, and what prejudice is being suffered by the non-offending party. That is the one that's opposing the introduction or didn't have the information or exhibit. I'm going to start with 104. Actually, all three of these have a different analysis, unfortunately. And I'll just mean that because that means I have to go through it 3 different times as opposed to giving you just one simple analysis for all 3.
Judge, I'm sorry.
Yes.
I just want to make sure. We haven't yet discussed the Richardson analysis for the modeling photo, have we?
Yes.
Oh, then I do want to add something.
Oh, please, yes.
Yeah. The prejudice to us. So the court may recall in my testimony, I specifically pointed out the drooping eyelid and the space between the brow and the eyelid. And the prejudice to us is going to be substantial because they're going to now introduce this picture taken at a completely different time with makeup and everything else. And they're going to argue that she looked like that here, therefore you can't believe what they said about the photo that was introduced, that was taken by the sheriff and staged on that day. And that's going to be substantial prejudice. Yeah, and one other thing, Your Honor, about the photo with the daughter and the father. No, there's a sympathy factor about calling the daughter to begin with, which was why we objected. So now this is a second bite of the apple. And if they want the photograph really just to show that Doug, by some crystal ball, they know he's not built like that underneath his shirt, then they should splice the photograph and remove Eva from the photograph if it's just to show Doug.
All right, thank you both very much. So 104 is an easy call. 104 is the mugshot, and that has been disclosed. It was used at the Stand Your Ground hearing, and in one of the more recent pretrial hearings, this in particular was one of the issues we talked about, and I was on my way to ruling that the state could not use it in its case in chief, but could use it in rebuttal, and that's where then one of the two of you jumped up and said that was your intent anyway, was to use it during rebuttal. So I don't find that there was a Richardson violation. That's been disclosed. It was discussed multiple times as this case is going on, so there is no prejudice there. As for 103 being the modeling photo, When did you get this picture?
It was I think it was the night, it was either the night before her, at lunch. It was at lunch during her testimony.
I found it on the internet while we were eating lunch and then turned it into an exhibit.
And tell me your prejudice for this again.
I had specifically pointed out when we put Ms. Benefield on the stand where the slap was upside the left side of her face, and asked her about whether her eyelid was, it reflected a droopy eyelid and swelling in the space from the eyelid to the eyebrow. And the state is now going to use that photograph to argue that that wasn't the case at all. There was no swelling, no damage, because here, take a look at the eye in this photograph. It's exactly the same.
Judge, I think that's.
And then they might just add, can I put this on the record ex parte? I don't want to help the state in their closing argument.
Okay.
All right. Surprisingly, I find this to be a much closer call. It's difficult to say that it was willfully held by the state because they didn't get it until the lunch. Well, direct happened in the morning, then we took a lunch break, and then cross happened in the afternoon. Let me ask you this, State, and I hate to do this because I know I'm usually very specific about I want to hear all argument and then I rule. When you procured State 103, you come back over, did you show it to the defense
I did.
prior to beginning your cross?
I did. Both of those pictures.
I'm sorry?
I showed them both of them.
Both of them?
And Judge, I just want to also add, the defense saying that they would not have spoken about the swelling on the side of her face, that same argument goes for the mugshot. And they had every reason to know that I was going to try and put the mugshot in after she put it into evidence. So I don't know that argument necessarily holds because they were on notice that I was going to make this argument, just maybe not with that picture.
All right, I do want to give you the final shot, though, since you're the objecting party. Anything else?
Well, the mugshot is 6 weeks later, and you can't discern from the mugshot what you can discern from this photograph that we are discussing now. I Again, the composition also of the photograph is different. This one is heavily with makeup.
I think that goes to the weight, not the admissibility. All right, so the state didn't have this until that day. They showed it to the defense prior to beginning their cross-examination. The purpose is not, I characterize it more as a rebuttal piece of evidence based upon the defendant's claim about the slap and so forth. And I understand why the state wants to use this, because they have 104 is coming in, which is the booking photo. But I look back at my notes just to see about 103. And on 103, when it was authenticated by the defendant, it was a modeling photo, and it was taken before she even met Doug, are my notes. So I have to find that there's some sort of prejudice and that the defense would have changed or been significantly different to meet that prejudice. And I just can't say that I find that, because the issue of the swelling above the left eye has been an issue since the stand your ground. And all 103 does is show the anatomical structure above the left eye at a time before she even met Doug. So I can't find that there's a Richardson violation. So 103, over the defendant's objection, is admitted. The predicate was laid. For 105, this is, again, it's difficult to say that it was willful because the state just obtained it yesterday or the day before. When's the first time you disclosed it? Today?
Today.
Well, I'm sorry, that's not 104. I apologize, Madam Clerk. 104, I found there was no Richardson. It is received.
Tomorrow.
No, I'll just do it now.
Okay.
103 and 104 received. 105. I don't think, first, so I can't find that it was willful. Trivial or substantial, I think it's certainly the relative size and physical abilities between the defendant and the victim is an issue. And the defendant has the photographs, whether they're from 2018 or 2020, the photographs of Mr. Benefield working out, where he is in, to put it mildly, extraordinary shape for a man his age. So I don't think it's unreasonable for the state to want to put in a photo of what he looked like a month before his death. I think it goes to the weight, not the admissibility of the photograph. With the argument between the two parties, defense can argue, yeah, but this shirt doesn't show him ripped. These other ones show him with his shirt off. They can make that argument. The state can argue that he wasn't as ripped and strong as he was in those photographs. But I don't disagree, and I've done this before, where editing the photograph for the fact of having his daughter in, and it's going to come out that there was a month before a month before his death. They're both smiling on a boat, having a good time. I think there's some, not the prejudice as preparation prejudice, but no, this would need to be.
I didn't get to respond to that. Can I just respond?
Yeah, go ahead.
Judge, I think the relative size of the victim to his 15-year-old daughter is very important in that picture, because the jury knows that his daughter was only 15 at the time that this picture was taken, and I think it helps gauge his size at the time of the murder, very shortly before. And if you crop the daughter out, there's nothing to gauge.
All right. I appreciate that. Overruled.
She was 19 in that photo.
Either way. Now, the question for you is, do you want this in,
I can crop it and print it out on a big piece of paper.
it's already been done.
Well, I was,
It's already done.
okay.
Right.
Oh, were you asking if I wanted the other half?
Yeah, do you want the other half?
Oh, I'm sorry. I didn't understand what your question was. I'll take the other half.
Well, I didn't know if you'd want it in the record, because you're saying you want it in. Do you want it in for?
Oh, we can just put it in the record then. Thank you.
Can I call that one 105A?
A, yeah.
That's going to be State's Exhibit 105A. It is not entered. So the only ruling I've made at this point is 105 is admissible as I have cropped it.
Okay,
But we still have the issue of, you want to get it in through Eva
yes,
Benefield,
yes.
and you're objecting her being recalled. So we still got to get that issue.
Yes.
All right.
Object to being recalled on two bases. One, sympathy factor, especially balanced against the probative value of this photograph, which is anybody's guess because he's got a shirt on. And two, based upon the hearing that we had.
Did you do any additional research on I made the ruling about the interview, right, that happened in the hallway?
Yeah.
All right. You had started to bring up some other matters, and I don't know if anything ever happened with that. No?
Yeah, I left it alone, I think, because she said she took the posts down.
Took them down. All right. All right, be heard on whether Eva Benefield, now, the rule of sequestration was applied.
Yes,
She was not released from her subpoena,
correct.
but she was allowed back in the courtroom pursuant to Marcy's law
Yes,
as next of kin.
yes.
All right.
And I think the entire reason for the rule of sequestration is to provide fairness. So witnesses can't hear what the other witnesses are going to say before they testify and where it may taint their testimony. I represented to the court like 4 questions I will have for her, and I don't think that any of those would have changed based on anything that she would have heard in the courtroom anyway. And even that being said, Marcy's law has shown that her right to be in the courtroom is more important than those types of issues anyway. So I'm not really understanding the defense's argument about her coming back in, and there are issues that are relevant to the state's case that the state wants to ask her. So I don't understand the sympathy argument.
All right, final thoughts, sir.
I think the sympathy argument is pretty obvious. And they already put her up there one time. So now we're going to put her back up there a second time. Marcy's law allows her in the courtroom. It doesn't allow her in the witness stand.
All right, thank you both very much. I made the findings the other day regarding what I understood to be about the brief interview that was given in the hallway. I believe there was an admonishment, and she was allowed to remain in the courtroom, although I will say she was kind of in and out. I don't find that it's overly sympathetic to recall her as a rebuttal witness to authenticate a photograph. You said something about the gym photos?
Right. She was going to talk about the gym photos.
How so?
When they were taken.
All right, and then right or left-handed.
Yes.
That doesn't sound like anything that would necessarily pull at the heartstrings. I will say this, obviously on that boat photo, it doesn't need to be, was that the last time you went on a boat with your dad and, you missed those times? It needs to be, when was this photo taken? And then you can make your arguments however you want to interpret it during closing. because that could be overly sympathetic to kind of dredge up those sorts of emotions.
Understood.
And then right or left hand, I don't see anything that's overly sympathetic or, I'm, in my head, I'm doing a 403 analysis. So I think the probative value is not substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading of the jury. And I don't find it to be needless presentation of cumulative evidence. So you may recall her for those limited purposes.
And Judge, if I could just see the picture where you cut, I'm cropping, could you see a picture of the digital copy?
Oh, that's exactly what you have. Is it where I have? Yeah.
All right, if that's everything we can handle tonight, you all are free to go, and we'll get started tomorrow morning. Yes, yeah, 8:45.
So it's fixed.